These are some insights on legislative and regulatory lobbying and the processes. I have discussed previously on my YouTube channel the legislative and regulatory processes here in California, as well as lobbying in both of these arenas. And I think I've also mentioned a number of the similarities and differences, of course, between these processes and lobbying in these two areas of public policy. But let's take a look at a few. First, in terms of lobbying at its most basic level, I've said there are similarities and differences between regulatory and legislative lobbying. But really simplistically, at the basic level, legislative lobbying is advocating for or against a bill in the legislative branch of government, whereas regulatory lobbying is advocating for or against a regulation in the executive branch. Obviously, there's advocating. It's a different type of measure, bill versus regulation, and obviously in executive versus legislative branches. So the processes and players are, of course, different, but the general concepts are basically the same. There's also, as a secondary matter, some interesting parallels between the two processes from my perspective. Some examples. Well, bills in the legislative branch as well as regulations in the executive branch can both do the same things in their respective areas of the law. A bill can add a new statute. A rulemaking can add a new regulation. A bill can amend an existing statute. A rulemaking can amend an existing regulation. And of course, a bill can repeal an existing statute, whereas a rulemaking can repeal an existing statute, an existing regulation, excuse me. In addition, the basis for an emergency regulation, as opposed to a regular rulemaking, is akin to the basis for an urgency clause in a bill, from my perspective. Both are designed to protect, the public health and safety, and of course, a need to go into near immediate effect. Regulations and bills have effective dates. For regulations, they're generally each calendar quarter, while statutes have effective dates generally January 1, with four specific exceptions that take effect immediately. Regulations and statutes can also have a delayed operative date. The formal legislative and regulatory processes both conclude in the same manner, by the way. The ministerial act of filing either the chaptered bill with the Secretary of State or the approved regulation with the Secretary of State. Moreover, both lawmaking forms, regulations, and statutes both have a notice requirement as well as an opportunity to comment period. These are the two key principles shared by both of these forms of lawmaking. In other words, the public and the regulated community needs to be made aware of the proposed law changes in statute or regulation, and then also be given a chance to provide their impact to the relevant decision makers. Now, while the regulatory process is based on statutes contained in the state's APA Administrative Procedure Act found in the Government Code, as well as some OAL regulations, the legislative process, of course, has both constitutional and statutory provisions, as well as internal rules to govern the legislative process. Now, on the regulatory side, interested parties mailing list exists pursuant to state statute for persons to receive proposed regulatory filings. This way, they're ensured of getting proper notice of proposed rulemaking activities. And so the regulated community and, of course, interested parties generally can be made aware of relevant regulatory changes that are being proposed. Likewise, individuals can sign up on LegInfo website to receive bill introduction notices and amendment notices of bills, resolutions, and even constitutional amendments proposed by the legislature. So individuals involved in the legislative process can also get notice of proposed lawmaking. As a result, interested persons are made aware of statutory changes as well as regulatory ones. And of course, with these notices comes an opportunity to participate in the legislative or regulatory processes. In both instances, there can be written or oral comments submitted. Now, on the regulatory side, there's a minimum 45-day comment period on proposed regulations. And this, as you can imagine, is the main opportunity to comment on proposed regulatory changes. There's often a formal hearing on proposed rulemaking as well, and sometimes one or more 15-day notices for additional comments. So again, interested parties can make both oral and written comments or presentations in the rulemaking process. Turning to the legislative process, a bill has to be in print for at least 30 days before it can be acted upon. And then bills are generally set for one or more committee hearings. And here too, interested persons, the regulated community, can submit written comments and also participate in public hearings in those committee hearings on legislation. So here too, in the legislative process, like the regulatory process, individuals can make both written and oral comments. Now, there are a number of these opportunities, right? So these are just a few of those similarities. Also, turning back to our topic of lobbying, in my mind, there's again a number of similarities between successful regulatory lobbying and successful legislative lobbying. I like to point out the three P's to be a good legislative or regulatory lobbyist: people, policy, process. People, do you know the relevant elected officials and their staff in the legislative process? Or perhaps the relevant appointed officials and their staff in the rulemaking process? Policy, do you know and understand the relevant policy area of the proposed rulemaking or legislation? And third, process, do you know and understand the applicable rules and procedures for the rulemaking process as well as for the legislative process? So obviously, this brief discussion is trying to demonstrate some of the similarities and acknowledge a few differences between these two processes of lawmaking in California so that interested persons and the regulated community can learn more about participating in these important governmental functions.